Hey everybody, John Skiba here, and in this video I'm going to tell you the two things that will absolutely blow up your bankruptcy. So if you're looking to file Chapter 7 bankruptcy in the near future, watch this video first. But if this is your first time here to my YouTube channel, please click subscribe. That way you'll be notified each and every week when I put out a new video that'll help you deal with your serious debt problem. All right, let's talk about bankruptcy. I'm going to be talking about Chapter 7 bankruptcy specifically. And when I do a consultation, when people come into my law practice here in Arizona, I often will ask, and by often I mean every single time, I will ask not only all the questions about debt and the assets and all that, but I ask two specific questions on areas that will completely blow up your bankruptcy if they're not handled correctly. And so I want to go over what those two questions are and what those two areas are, so that if you're looking to file Chapter 7 bankruptcy specifically, this is something you need to talk about with your attorney because it can cause you some serious problems. The first one is called preferences. A preference is where you pay back a debt that you owe. And this is particularly problematic when you owe a debt to a family member or a close friend or like a business associate. So let's say that I owe my parents $10,000. And in the year prior to filing bankruptcy, I paid that $10,000 back. In the eyes of the bankruptcy court, even though what you did is completely legitimate and appropriate, in the eyes of the bankruptcy court, that is what's known as a preference, meaning that you gave your family preferential treatment over the rest of your creditors. And if you paid your family back, if you paid a friend, family member, business associate, if you paid back a loan to them in the 12 months prior to the filing of your bankruptcy, the bankruptcy trustee that's assigned to your case can go back and get that money back. Usually they send a letter to your family member, friend, whoever you paid back and said, hey, this was a preference, you need to send those funds to my office. If your family and friends do not do that, they will get a federal lawsuit filed against them requiring them to turn it over. And if they don't have the money, they could end up having a judgment entered against them. So preferential payments to creditors, particularly what we call insiders, family members, friends, those things can cause huge problems. And so if you owe money to a family member or a friend, you may eventually pay them back, but you don't want to pay them back in the 12 months prior to the filing of bankruptcy. So you may be asking yourself, okay, well, what if I've already done this and I need to file for bankruptcy? That happens quite a bit. In a situation like that, what you have to deal with is you either need to wait a full year since that payment's been made, or alternatively, what you need to do is be prepared to make some type of settlement proposal. You as the debtor could reach out and to the trustee and offer some type of proposal to resolve the issue. I've seen that happen before, particularly when the amounts are small. Let's say that you had paid back a family member $1,000 over the last year. The trustee may be willing to negotiate with you directly rather than going to the family member where you pay back that $1,000 or something close to that so that to resolve the claim. So I know those aren't great options, but that's really what you're looking at if you need to resolve the preference. It's important to know that there could also be preferences to creditors who are not family members, but the look-back period is not as long. It's 90 days prior to the filing of your case if you pay back a creditor more than they would have received in a normal situation. So, for example, let's say you owe $10,000 on a credit card and your monthly minimum payment is $250 a month, but you decide within 90 days prior to filing bankruptcy, for whatever reason, to pay them off. The bankruptcy trustee will go back to the credit card, get that money, and distribute it pro rata amongst all of your creditors. Everybody will get a portion of it, not just that one creditor. You can't prefer them. That's why it's called a preference. So it applies to both what we call insiders, family members and friends, as well as to non-insiders, just regular credit card companies, medical bills, that kind of thing. The second thing that we look at that can cause big problems in your Chapter 7 are what are known as fraudulent transfers. Now, I know what you're saying. You're probably thinking, I would never do anything fraudulent. That's not me. I'm not the fraudster here. And the word fraudulent here is used in a legal sense in that it really applies to any transfer in the 2 years prior to filing of your bankruptcy where you transfer the asset for less than it's worth, and you're insolvent at the time or essentially facing bankruptcy. Essentially, you're running out of money, you may be broke completely, and you start transferring assets. The area where we see this pop up quite a bit is someone will have a vehicle that's paid for and they take their name off the title and put it in their brother's. Or they have a boat, they know they're going to have to file for bankruptcy, they come to me and they say, don't worry, I transferred my boat to my dad and it's in his name now. Big problem. That's known as a fraudulent transfer, even if your intent wasn't fraudulent. I see the area where I see it happen innocently quite a bit is when teenage children of people who are filing for bankruptcy. So say I'm filing for bankruptcy and there's a car that say my 18-year-old son has been driving since he turned 16. I transfer the title over to him so that he has that vehicle. Even though that's completely innocent, it's still considered a fraudulent transfer. And if it happens within the 2 years prior to filing bankruptcy, the court can unwind that transaction. They do it the same way. They're a bull in a china shop. They make demand, or they go and they try to bring the asset back into the what's called the bankruptcy estate, and then they can sell it and give the money to your creditors. So if you transferred any assets for less than what they're worth during the 2 years prior to filing for bankruptcy, there may be problems. It's important to note, though, this doesn't apply to like just regular transfers. Let's say you do have a vehicle and you sell it on Craigslist or something for approximately what it's worth. That's fine. It's also fine if you owe money to someone and you're transferring them like a vehicle or an asset to cover a payment, as long as it's basically equivalent value. You know, the main thing where you're going to have problems is if you were to sell your vehicle to your brother, it's worth $10,000, but you sell it for $500. That's a problem. So those are really the two areas that can cause the most grief and probably the most litigated areas in a Chapter 7 bankruptcy, are preferential payments to insiders and non-insiders, as well as fraudulent transfers where there's been a transfer of assets within the 2 years prior to filing bankruptcy. So I hope that helps, gives you a little bit of understanding of the bankruptcy processes and why you don't want to just dive in, and why it's important to have an attorney. I do practice bankruptcy law in Arizona. I do offer free consultations on my bankruptcy cases. I'll put the link down for my law firm in the notes here. If you're in Arizona, I'd be happy to help you, and appreciate you watching today.